Welcome back for our second panel, Rights and Federal Cognates. And during this panel, our distinguished panelists will look at specific rights protected in Article 2 of the state constitution that are also protected in the federal constitution. And interestingly, all four of these provisions were taken directly from the Washington state constitution. So we'll explore how the language and interpretation of these provisions resembles, or not, their federal cognates. Our panelists really need no introduction, like many of the speakers today. So I will refer you to the CLE materials that you have printed or in your email for detailed bios of our speakers. So let me just mention their current positions and the right that they will be talking about. First, we have Justice James Beene, who will be discussing the free speech provision in Article 2, Section 6. Justice Beene was appointed to the Arizona Supreme Court in 2019. He has also served as an Arizona Court of Appeals judge and a Maricopa County Superior Court judge. Next, Dave Euchner will talk about the Private Affairs Clause in Article 2, Section 8, and the exclusionary rule. Dave is an appellate unit supervisor and resource counsel of the Pima County Public Defender's Office and a professor of practice in criminal law at the University of Arizona. Next, Professor Ilan Wurman will discuss the privileges or immunities provision in Article 2, Section 13. He has asked for everyone's reserved time, so anyone who has extra time, Ilan wants it. Ilan is an associate professor at that other law school in Arizona, where he teaches admin law and constitutional law. And then last but not least, Justice John Lopez will discuss the right to keep and bear arms in Article 2, Section 26 of the Constitution, and his thoughts on social justice, apparently.
Wow.
He was appointed to the Arizona Supreme Court in 2017, and prior to his appointment, he was Solicitor General for the state of Arizona. Now, before we start, and I'm well prepared to keep time. I'm a frequent timeout timer in my house, so I've got my stopwatch ready to go. But before we start, I thought perhaps Justice Beene and Justice Lopez would like to respond about the case and controversy requirement, or not. But I thought it was fair game. We have a little extra time. Any thoughts?
I don't respond to Judge Moore.
Oh, okay. Justice Lopez?
He responds to me. So.
Any thoughts?
I'll even the ledger when reviewing cases he authors that our court reviews on appeal.
Okay, well, with that, then we will start with the free speech clause.
Thank you, and thank you for the invitation, Federalist Society, and specifically Judge Perkins, thanks for the invitation. As Justice Bullock referred to earlier, Article 2 of our state constitution is entitled Declaration of Rights. The substance of this article is its guarantee of individual rights for Arizona citizens. And a number of the rights found in Article 2 resemble the rights secured in the Bill of Rights of our federal constitution. And Arizona's citizens' right to freely speak, write, and publish is found in Article 2, Section 6 of our state constitution. And since we're here in a symposium with Originalism in the Arizona Constitution, I thought I'd like to reiterate the actual text of this provision found in Article 2, Section 6. It reads as follows: every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. Now, clearly, Article 2, Section 6 of our state constitution is the cognate of the free speech portion of our First Amendment of the U.S. Constitution that provides that Congress shall make no law abridging the freedom of speech. However, as you can tell by what I just read of the Arizona constitutional provision, the text is quite different in these two constitutional provisions. And in the spirit of our originalism theme today, I thought it would be both interesting and helpful to review the history regarding how this particular section and the specific language that makes up Article 2, Section 6 came into being. In my research, I attempted to determine whether this textual difference was purposeful by the delegates to the Arizona Constitutional Convention. And I believe, probably as many of you all, any research that needs to be done on the history of the Arizona Constitution I think we all first consult the leading treatise on this subject, and that's the Records of the Arizona Constitutional Convention of 1910 that was edited by John Goff and published back in 1991. I thought that this tome on the Arizona Constitution would provide a rich and robust source of how Article 2, Section 6 came into being, how the debate was shaped by the delegates regarding what I believe to be the seminal right, a right that was going to be clearly enshrined in our state constitution. Kind of more importantly, and maybe selfishly, I wanted to know, would Goff's treatise cast any insight on the framers' debate regarding this particular part of the Declaration of Rights and provide any useful and applicable information about the meaning of its provision outside of the text that might be useful in what I do on a daily basis. I don't know if many of you have ever had the opportunity to read or even peruse the records of the Constitutional Convention that John Goff put together. It is an impressive compilation, and I would submit that maybe you should take a look at it in your practice. There is a section of Goff's book entitled Convention Proceedings, and it reads a lot like a transcript of the Constitutional Convention. The Constitutional Convention began on December 10th in 1910 and concluded nearly 2 months later on December 9th, 1910. And the convention proceedings took up just a little over 1,000 pages of Goff's book. And in conducting my research on this issue, I discovered that a whopping 35 pages of those 1,000 pages of the transcripts are dedicated to the delegates' debate on Article 2 of our state constitution. Not exactly the rich treasure trove I thought I was going to find or expecting to find regarding the debate on Article 2, Section 6 of our state constitution. In fact, the text that would eventually constitute Article 2, Section 6, the text that we now know is markedly different than the similar rights found in the federal Constitution, was actually never discussed by the delegates to the Constitutional Convention. The language that eventually became Article 2, the Declaration of Rights, was proposed by a delegate by the name of William Cooper. He was from Pima County. And Cooper's proposal was designated by the convention as Proposition 94. Proposition 94 was first addressed by the convention on November 25th of 1910, and at that time the delegates were informed that the proposition was taken entirely from the Washington State Constitution with 2 or 3 small omissions. The committee that was assigned to review Proposition 94 eventually decided to recommend the entire Bill of Rights from the Constitution of the State of Washington to the Constitutional Convention. Really, the only amendment of any significance or import to the Washington State Bill of Rights that the Arizona delegates added to Proposition 94 dealt with the hot topic of the prohibition of imprisonment for debt. On December 5th of 1910, the Committee of the Whole took up the discussion of amended Proposition 94, and the Committee of the Whole then began to discuss Proposition 94 section by section. And when the discussion came to the rights that are enshrined in Article 2, Section 6, again, no discussion regarding the topic. Surprising. One day later, on December 6, 1910, the Constitutional Convention adopted Article 2, the entire Declaration of Rights, by a vote of 42-7, again, with no discussion, substantive or otherwise, about this particular right. Sorry to burst your bubble. That is the historical background regarding Article 2, Section 6 of our state constitution, at least I was able to uncover. There really is not much there. So I found this somewhat interesting, a bit confounding, that there was no discussion at all on this topic. And not surprisingly, I couldn't find any contemporaneous newspaper coverage that discussed this section of the state constitution. I conducted a fairly extensive online research of this, looking for this type of material, and didn't come up with a single article regarding this specific provision of Article 2. I guess that probably doesn't surprise anybody that if it wasn't discussed, it probably wasn't going to be covered in the newspaper. Next, I looked at the historical context in which this constitutional provision was adopted. And as somebody mentioned in the last panel, the two movements that were in its ascendancy during the territorial times was the progressive movement and the labor movement. The labor movement was finding a particular resonance in the fertile ground of the mining towns in Arizona. And the two movements, these were really the two movements, historical movements or backdrop in which our state constitution was adopted. And again, I struck out here, there was absolutely no record that these two political movements informed Article 2, Section 6 of our state constitution. I did find it interesting, though, that the Arizona Supreme Court, the first time that it addressed Article 2, Section 6, was in a case called Truax versus Bisbee Local number 380, and it addressed the right to freely speak and publish as it applied to members of a labor union. So there was some tangential relationship between the historical context and this section of the state constitution. In Truax, the state Supreme Court held that speech and demonstration by striking restaurant workers could not be restrained because of the rights contained in Article 2, Section 6. And I won't go into the facts of the specific facts of this case, but there have been commentators on the Truax decision, and they've stated that the Arizona Supreme Court's first foray into the meaning of Article 2, Section 6 can be characterized as a ringing statement in favor of a broad interpretation of this constitutional right. And I know that really excites Justice Bullock. So, in preparing for my remarks today, I also examined whether other states used comparable language regarding freedom of speech and the freedom to publish when enacting their state constitution. And I was lucky enough to stumble upon a case out of Division II, the Court of Appeals in 2004, a case called Empress Adult Video and Bookstore versus the City of Tucson. And in that case, the Court of Appeals did actually great work in setting out the history surrounding the language found in Arizona's constitution as well as other state constitutions. In Empress, the court found that there were some 40 other state constitutions that contain this provision with language that was substantially similar or identical to Article 2, Section 6. I'll just go over a few. The California Constitution contains almost identical language as Arizona's provision, and the California Supreme Court considers their state constitutional provision more definitive and inclusive than the First Amendment. And in the state of New York, the state of New York's constitution has a free speech provision that closely mirrors Arizona's, and their state's highest court has concluded that its free speech provision is often broader than the minimum required by the First Amendment. My final example, my tip of my hat to my colleague, Article 1, Section 8 of the Texas Constitution, which again is nearly identical to Arizona's provision. The Texas Supreme Court has held that its provision ensures a broad liberty of speech. And since we know that Arizona the delegates took the identical language from Washington, the Washington Supreme Court has had a chance to opine on this part of their state constitution, and they've held that the free speech provision often will support a broader protection for speech than the federal constitution. And finally, I did a little survey of Arizona law on this provision, and under both the First Amendment of this First Amendment of the federal constitution and Arizona's Cognate Article 2, Section 6, a number of the opinions from the appellate courts have determined that the federal test or analysis in this area was inconsistent with the broad protections afforded by the Arizona Constitution. So I think it's fair to say, as much as I can say without breaking my oath or opining on how I might rule in a case, that the case law out there shows that Arizona's Article 2, Section 6, the cognate to the First Amendment and the federal Constitution, has been viewed as providing broader protections than the federal Constitution. So I was a little surprised, a little saddened that there wasn't more history on this that I could share with you all, but I do appreciate the chance to to share what I have found with you all on this, what I feel to be very important portion of our state constitution. Go ahead, clap. Yep.
At least your Supreme Court justices get claps after.
All right. Well, thank you very much for having me today. Thank you for Judge Perkins for inviting me, and it's a great honor for me to be on this panel with these esteemed jurists next to me, although based on what I say afterwards, one might question that, but I'm sincerely honored. I do want to begin with the disclaimer that all the cases I'm going to talk about that are recent in time, I am a little biased. I lost every single one of them, either as the party or as the amicus. Most of them Justice Lopez authored.
This is why I'm going third.
So
Okay, I see.
there's a fine line between critique and a festivus airing of grievances. If I stray a little across the line, if I didn't, it wouldn't be as much fun. But imagine Frank Costanza's face right here as I go forth. So, as was already mentioned, all of the rights that we're talking about were taken from the Washington Constitution. Article 2, Section 8 states, "No person shall be disturbed in his private affairs or his home invaded without authority of law." And this comes verbatim from Washington Constitution, Article 1, Section 7. So this had, as Justice Beene noted, there was very little attention given in the 1910 convention. Professor Leshy's text on the Arizona Constitution gives 8 pages to all of the Declaration of Rights and very little to the Private Affairs Clause. The first case that talked about the state constitution was in 1926, Malman versus State. And the court in that case just said that even though the language is different, it's intended to protect the same effects as the Fourth Amendment, so it interpreted it consistently with the Fourth Amendment. And after that, there really was not any discussion of the state constitution until we get to the 1980s. And in 1984, the US Supreme Court decided a case called Segura, which allowed police officers to come into a home and secure from within while the warrant was being obtained. And right after that, the Arizona Supreme Court decided a case called Bolt, where they didn't like the result in Segura. They were afraid that if Bolt went up to the US Supreme Court, that it would get overturned. So the court said, we think that this is protected by the defendant's protected by the Fourth Amendment, but just in case, we're gonna decide this on independent state grounds, Article 2, Section 8. So that's the first case that gives a little bit of extra ground to the state constitution. In that same case, when moving to the exclusionary rule, Chief Justice Feldman wrote, "The only thing worse than having one exclusionary rule is 2 exclusionary rules." So the court specifically said, we're not going to look at this as a state constitutional exclusionary rule. Then 2 years later, in a case called Alt, the police entered a home without a warrant. It was found to be an illegal search. And when the state argued inevitable discovery, at that point, the Arizona Supreme Court said, we're going to say that Article 2, Section 8, exclusionary rule under the state constitution, protects the defendant from this kind of a search, and we're not going to allow an inevitable discovery exception when it's a home search. So that's all we've got. We've got Bolt in 1984 and Alt in 1986. And then time marches on. And a certain justice on the Supreme Court started writing concurring opinions saying people should start talking about the state constitution. Our keynote speaker wrote a separate opinion in State versus Gene that said, which was a very divided, it was the only opinion I've ever read where the majority opinion was written by 2 justices, each of whom dissented in half of the opinion. I had to create a Venn diagram to figure out who was deciding what. But Justice Bullock wrote an opinion saying this is a really hard decision because the parties only argued it under the Fourth Amendment. If this was submitted under Article 2, Section 8, we would have had an easier time because we wouldn't have had to worry about deciding reasonable expectation of privacy. We could have looked at the Private Affairs Clause. Now, there were amicus briefs that argued the state constitution, but the Gene's lawyer in State versus Gene did not argue it. Later that year, in a case called State versus Hernandez, the parties did argue the state constitution. Amicus briefs from the Goldwater Institute argued the state constitution. And then the Supreme Court decided the case on Fourth Amendment grounds, didn't really analyze the state constitution, but said it wouldn't have provided any additional protection. And it wasn't shown that there was a convincing argument in this case for additional protections. So interested parties went to the drawing board, one of whom was Tim Sandifer, and he wrote an article that was published in the ASU Law Journal in the summer of 2019 called Arizona's Private Affairs Clause. Coincidentally, at that same time, a case was coming up through my office and made its way to Division II called State versus Mixton. And when the Court of Appeals decided it, the three-judge panel wrote three separate opinions. So the majority opinion said that the conduct in that case did not violate the Fourth Amendment, but it violated Article 2, Section 8. And this was a case where it was a child pornography case with somebody trading child porn images online using an anonymous app for trading images and messaging. So the state got an administrative subpoena to get the IP address from the app, and then went with an administrative subpoena to Cox to find out who the subscriber was. The state petitioned for review on the state constitutional issue, and Mixton petitioned on the federal constitutional issue, as well as on the application of the exclusionary rule, which I'll get to later as well. The Supreme Court took review of the Fourth Amendment and Article 2, Section 8. And then in January of 2021 issued a 4-3 opinion. The majority in Mixton decided that the Fourth Amendment did not apply to Mixton's conduct because of the third-party doctrine, which SCOTUS developed in the 1970s, that says if you share this information with a third party, for example, a bank or the telephone company, that gives license to the police to come in and say, that person has no privacy in that interest, give it to us. The third-party doctrine had never before been applied in Arizona until Mixton's case. So this is the first case that says the third-party doctrine officially applies in Arizona. Article 2, Section 8 had been thoroughly argued not only by Mixton, but also by the Goldwater Institute, by the Institute for Justice, and the Electronic Frontier Foundation in amicus briefs. So the court reached Article 2, Section 8. As Justice Beene just mentioned, there was looking back at the records of the Constitutional Convention to see what was decided, what was discussed, and there was a paucity of information. So the question then came to the court, what do you do with the silent record in this case? The court decided that the silent record supported following the Fourth Amendment. There wasn't compelling evidence to say that we should have a distinct interpretation from the Fourth Amendment. There was a vigorous dissent, to say the least. The dissent said that the different language meant it had to have a different meaning, that the private affairs clause meant something. It disagreed with the majority's likening of the private affairs clause in the state constitution to reasonable expectation of privacy in the Fourth Amendment, because that phrase, reasonable expectation of privacy, didn't come around until Katz in the 60s. There wasn't even a privacy right under the Constitution until Griswold in 1965. So this could not have been what the founders meant in 1910 and 1912 when they were writing the private affairs clause. Furthermore, there was the third-party doctrine was incompatible with the textual language of Article 2, Section 8. It was intended for, I'm getting the poll warning. So the Mixton is in the materials, but I do want to get to the other case that I wanted to discuss as well. I wanted to talk about the exclusionary rule. So the exclusionary rule was developed by the federal Constitution, the federal Supreme Court in 1914, and Washington Supreme Court in 1922. And the basis of it was judicial integrity. If law enforcement breaks into somebody's house, seizes evidence, we can't have the judiciary endorsing the admission of this evidence. It would violate judicial integrity to allow that evidence into court. And that was the law up through until the 60s when the idea of deterring police first trickled into some SCOTUS cases like Elkins. But it wasn't until the 1970s when the US Supreme Court abandoned judicial integrity and went with police deterrence. Around the same time in the early 60s, we had Mapp versus Ohio, which officially incorporated the exclusionary rule to the states. So most states, including Arizona, then just followed the federal exclusionary rule. The Washington Supreme Court in 1982 realized that the US Supreme Court had retreated from judicial integrity too far and then went back to its roots. So the Arizona Supreme Court has the opportunity to do the same and go to its roots and breathe life into the state constitution. In a case called State versus Weakland that was argued in 2018 and decided in 2019, Weakland did not argue the state constitution, but a certain amicus brief author filed 2 briefs suggesting it. But because amici cannot enlarge the issues, the court didn't reach the state constitutional issue that had been raised. But should the court have the opportunity to reach the state constitutional issue in the future, it is ripe for a new interpretation that goes beyond what the federal Supreme Court is doing, especially when we consider the fact that what we see from the US Supreme Court is in exclusionary rule cases, the court says you can file a 1983 lawsuit, Section 1983. And then when Section 1983 suits are filed, the court says that there's qualified immunity, which is a judge-made doctrine that is not based in originalism at all. So people who are wronged by the police are in a catch-22. The US Supreme Court is not making any movement toward repairing that. The Arizona Supreme Court does have that opportunity to do it on independent state grounds. Okay.
Okay, no, I'll use this. I have so many questions for the prior 2 panels. And I see Justice Lopez preparing a rebuttal, I think, to the right here. So I kind of just want to melt away into the wall and skip my piece. But, well, thank you so much for having me here at this conference. Some quick background about why I'm here, other than that I write on the, I don't know if you heard my students chuckling when I was introduced to speaking about the Privileges or Immunities Clause. What don't I talk about these days other than the Privileges or Immunities Clause? That's basically all I talk about, the federal Privileges or Immunities Clause. So why am I here talking about the state Privileges or Immunities Clause? So that's sort of another backstory, which is in 2020, I filed a lawsuit on behalf of 130 bar owners who were shut down by one of Governor Ducey's executive orders, promulgated pursuant to a statute that purported to give the governor all police power of the state in the event of an emergency. And we had these 2 principal claims, and one was obviously a state non-delegation claim, but the other was an equal privileges or immunities clause claim. We said, you know, if you let restaurant bars stay open and hotel bars stay open, but not our bars stay open, that this violates the clause. I guess I should say before I go on, are any of the governor's lawyers in this room? To channel Judge Morse, I'm here not to bury them, I suppose, but just to have the last word. Any relatives of the governor's lawyers? Okay, good. So I wrote an article in the NYU Journal of Law and Liberty, which I distributed some off-prints. Please take them. I do not want them in my office anymore. They've been here for far too long. Kind of discussing the litigation and the theory of the case and the various state cognates that we sued under to the federal constitution. So we had, you know, state non-delegation challenges, state equal privileges or immunities challenges, and the article talks a bit about contracts clause, which wasn't relevant there, and also the law of municipal corporations, which is seriously underrated and important. So that's obviously a lot to cover, and I've been given initially only 7 minutes before the last panel ceded its time to me. So it's a lot to cover, so I'm not going to talk about all of that. Instead, just give me an opportunity to talk about the privileges or immunities theory. And I relish the opportunity to speak about this theory because 2 of my co-panelists decided 3 days before oral argument that the case had become moot. And so now they have to listen to me. They are now my captive audiences for the first time ever. So they have to hear me out at least on this theory. Okay.
You have Justice Bullock's attention as well.
Oh, that's right. Yes, that's right. Unanimous decision that it was mooted. Okay. So here's the question. is the state legislature or the governor or an agency entitled to rational basis deference when the Privileges or Immunities Clause of the state constitution is implicated? What is the framework for addressing privileges or immunities cases? Okay, here's the text. No law shall be enacted granting to any citizen, class of citizens, or corporation privileges or immunities which upon the same terms shall not equally belong to all citizens or corporations. Now, in my view, the state Privileges or Immunities Clause does exactly what I think the federal Privileges or Immunities Clause was intended to do. It requires equality in civil rights under state law. Now, why is this important to compare to the federal cognate, which is not equal protection, by the way, it's the federal Privileges or Immunities Clause, is because the federal provision, which hasn't been relevant since 1873, but just put that aside, uses the word abridge. What does the word abridge mean? Is it an absolute protection for certain fundamental rights? Does it only guarantee equality? Does it guarantee both? Well, what we know from the state constitution is it's an equality guarantee. What does that mean? It means states have wide leeway to define and regulate the content of rights. Maybe they can even abolish them altogether, right, barring some other constitutional protection for those rights. So they have wide leeway to define and regulate rights, all rights, gun rights, speech rights, property rights, contract rights. What they can't do is discriminate in the provision of those rights. Well, how do we know what is a regulation of the content of a right and what is a discrimination or an abridgment of that right, to use the federal term? Well, let me propose an answer. I think the question that has to be asked is whether the purported regulation reasonably relates to the purpose of the right. Okay, so the black codes in the South after abolition that systematically denied civil rights to the newly freed people, right? If you were a recently freed slave or the newly freed people in the South, they weren't allowed to own real property. They weren't allowed to possess guns. Okay, this was understood by all to be an abridgment. Why? Well, because skin color obviously has no relation whatsoever to gun rights or to property rights or to contract rights. It's just irrelevant. It's irrelevant to the purpose of the right. It's an abridgment, not a regulation of the content of the right. Similarly, a law that says gays can own property, okay? Think about like the gay codes instead of the black codes. It doesn't matter whether being gay is a suspect class or not. It's a totally irrelevant question. The law would be equally and just as obviously unconstitutional because being gay has nothing to do with the purpose of property rights. A monopoly, to take another example, almost never has any relevance whatsoever to any right. Okay, it's just a grant of exclusive privileges, so Slaughterhouse was wrong. Monopolies were the quintessential example at common law of abridgments, of discriminations. Okay. As was Lee Optical, by the way, which effectively gave a monopoly or an exclusive privilege to a favored class of elite citizens on a basis totally irrelevant to the purposes of the privilege at issue there. Okay, now let's take a harder example. Is limiting marriage to opposite-sex couples merely regulating the content of the right of marriage, or is it an abridgment by discriminating in the provision of that right to gay individuals? Now, I think this question boils down to what are the purposes of marriage and whether gay individuals can participate in those purposes. This is a harder question than the black codes or the hypothetical gay codes that I mentioned or the monopolies. Why? Because we all know that sexuality has something to do with these purposes, right? So whatever your answer to that question, my only point is that this is the question that has to be asked in terms of how we determine what's a regulation versus what is an abridgment. Now note the important point, I suppose, is that none of this analysis, okay, in none of those examples has anything to do with strict scrutiny or intermediate scrutiny or rational basis scrutiny. It is the same test. It is the same question for all rights, economic rights, personal rights, social rights, and for all regulations. Regulations based on skin color, based on sex, based on sexuality, based on occupation. It's the same question. Now, the answer to it, okay, might be more obvious if we're dealing with skin color, right, than if we're dealing with something else, but the question is the same. Now, to be sure, if reasonable people can disagree on the answer to that question in the particular context, then maybe some judicial humility is appropriate, but that is nothing at all like the modern, highly deferential rational basis test, which is totally comes out of nowhere and has no basis in either the federal or the state constitution, but I think it's particularly clear in the state context. Okay, now because Justice Bullock mentioned Lochner, let me say one thing. Does this mean that Lochner was right? I don't think so. Sorry to burst your bubble. No bubble burst, okay. Lochner I don't think involved discrimination. All bakers were required to submit to a maximum hours requirement. Now, to be sure, before Paul Avalar screams something at me, you could always more broadly define the right. For example, as the right to earn a living. Okay? But in that case, right, maybe the law then discriminates against bakers by not applying a maximum hour laws to optometrists. Okay? So in that case, maybe it's a discrimination. But or you can make a plausible case of discrimination. But the more broadly one defines the right, I think the easier it will become for the state legislature to claim that it's reasonably regulating the content of the right rather than discriminating in its provision, because there are obviously good reasons to treat bakers different than optometrists. Okay. Let me wrap up by saying, just because I have a microphone and I said I'm here to have the last word over the governor's lawyers, how did this shake out in the bar owner's case? Well, I would say that establishments that were trying to engage in this same activity, they were trying to engage in the same activity of selling liquors to patrons. And if a restaurant licensee can operate a nightclub on the weekends, which we showed at trial that they could and were doing, then it was unreasonable and therefore in abridgment. Okay, it doesn't matter whether you can conceive of a rational reason why, right? Some legislature might think it's rational. If you can prove at trial that in fact it is unreasonable, that should be enough for the state equal privileges or immunities clause. So if restaurants could operate as nightclubs, then I think mom and pop wine bars in Prescott should probably be allowed to be open. This is another way of saying having a restaurant license had no relevance whatsoever to the purpose of the right? The serving of alcohol in a safe and healthful manner in a way that minimized the risk of disease transmission. Okay, anyway, despite our case being mooted, I hope that this argument and the other state cognate arguments that we raised might be helpful in future challenges to assertions of emergency authority in other circumstances. And that's what I wanted to say, the last word. Thank you.
All right. Before I address Article 2, Section 26, I want to make 2 points unrelated to this topic.
Welcome to our conference.
Professor Wurman said that he thought I was scripting a rebuttal to Mr. Euchner's comment. Since Mr. Euchner mentioned Frank Costanza, I was actually writing furiously and repeatedly, "Serenity now." Second point, since it was mentioned twice that I'm a self-styled social justice warrior, I thought I would use this platform, and feel free to approach me after the panel concludes. My movement really consists of two pillars. One, under the banner of equity, I think we should use the instrumentalities of government to impose universal economic and social outcomes for every citizen. And two, we're ardent supporters of free speech, provided speakers agree with us and they don't hurt people who matters feelings, which means members of our movement. So if anyone's interested, please, I'd love to speak with you after the panel. So now returning to the business of the day, Article 2, Section 26, I would accuse Justice Bullock of stealing my thunder, noting that the obvious textual differences between the Arizona constitutional right to bear arms provision and the Second Amendment to the United States Constitution, but it's self-evident. The salient portion of the Arizona provision reads, "The right of the individual citizen to bear arms in defense of himself or the state shall not be impaired." Obviously, that forecloses any litigation concerning whether the right is conferred upon an individual. And so that point is obvious, and I could wrap up there. But there is an interesting history, and actually, unlike so many of our constitutional provisions, there's actually a very fulsome record of debate about the language of what ultimately became Article 2, Section 26, and some very relevant qualifications to that right, which ultimately culminated in a couple of appellate court cases here. So I'll work my way through, and I've sort of followed the outline that Justice Beene did. So first talking about the text, the textual differences are obvious. The controversy that I'm going to discuss, which is really the only meaningful controversy in our jurisprudence about the meaning of Article 2, Section 26, concerns the manner in which a citizen may exercise that right, what manner is protected, and specifically whether Article 2, Section 26 protects a citizen's right to carry a concealed weapon. And that's what my comments will relate to, because that really is what's interesting about this provision. So looking at the Constitutional Convention record, there were a number of motions to modify or strike the language that was ultimately adopted. First, famously or infamously, whatever your view, Delegate Baker moved to strike the right altogether early on in the discussion of this right, and he employed what I consider not a terribly convincing argument, which is advanced by folks who are ardent supporters of strict gun control. These are quotes from his speech. Carrying arms is dangerous. Therefore, no one should have a right to do that. And he also said that he had, and this comment provides some interesting insight about what the founders thought that this rather broad and unqualified right ultimately adopted in Article 2, Section 26 meant. He said, in advance of his position or defense of his position, I have seen lives lost and innocent blood spilled just through the carrying of arms, concealed weapons, under one's coat or shirt. And then he concluded by saying, I do not believe in it, in the right to carry a weapon, and I moved to strike out that section. Of course, that was rejected. Nevertheless, there were another couple of proposed amendments to the provision which clearly had votes. The first was a motion made to replace the provision altogether with the following alternative. The people shall have the right to bear arms for their safety and defense, but the legislature shall regulate the exercise of this right by law. That motion failed on a voice vote. The second, which was a similar amendment, followed the word impaired, which I read to you at the beginning of my comments, and said, but the legislature shall have the right to regulate the wearing of weapons to prevent crime. That amendment failed by one vote, 22 in favor and 23 against. So it was rejected. There were a couple of other attempts or proposed alternative versions of the section. Each of them expressly conferred upon the legislature the authority to regulate the carrying of arms or to expressly ban concealed weapons. And all of those amendments were subsequently rejected at the convention. Now, looking at comparable clauses in other state constitutions, you've heard it a number of times. Article 2, Section 26 was nearly verbatim, but substantively identically adopted from the Washington Constitution. New Mexico, which adopted its constitution fewer than 2 months after Arizona adopted its, adopted the following bear arms constitutional provision. The people have the right to bear arms for their safety or for their security and defense, but nothing herein shall be held to permit the carrying of concealed weapons. So they expressly banned concealed weapons. Vermont, Kentucky, Pennsylvania, just as a representative sample, had language, unqualified language, similar to Arizona's. And so these were provisions that the founders clearly, we impute their knowledge of. Now, pre-1910 case law interpreting other state constitutions, similar provisions. Washington in 1907, in a Washington Supreme Court case, noted that its courts had, quote, uniformly held that the constitutional right to bear arms is subject to reasonable regulations under the police power. So they read this reasonable regulation authority, conferred it to the legislature, even though it was not expressly conferred in the constitutional language. Vermont and Kentucky, in cases in the middle 19th century and the very early 20th century, before the Constitutional Convention, each rejected ordinances prohibiting the carrying of concealed weapons. on constitutional grounds after interpreting similar constitutional language. Now, this issue is complicated even further by the state of the law before and after the Constitutional Convention, after the Constitution was adopted. The 1901 Arizona Territorial Penal Code expressly banned the carrying of concealed weapons. Then, after the Constitution was adopted in 1913, by virtue of operation of Article 22, Section 2 of the Arizona Constitution, which read, "All laws of the territory of Arizona now in force," meaning the territorial code, "not repugnant to this Constitution, shall remain in force." The entire territorial code thus was codified as new law in our state. But interestingly, the code commissioner, who was charged essentially with a ministerial act of simply adopting all of these laws, was not tasked, nor did he have the authority to determine whether the territorial law was repugnant to the Constitution. So now advancing to the current state of the law and how we got here. As I noted, the primary jurisprudential issue in Arizona has been, again, whether this provision confers a right to carry concealed weapons. There are two appellate court cases. The first, the Dano v. Collins case from 1990, and then the State v. Wurman case in 1994. Each of those cases held that Article 2, Section 26 did not confer a right on citizens to carry concealed weapons. In the first case, the Dano case, the court adopted what I would describe as a watered down, what the court described as a hybrid strict scrutiny standard, which involved considering a legitimate government purpose, not a compelling one, that must be narrowly tailored. And the court essentially concluded that embracing Washington's interpretation of their constitutional provision, that the legislature had the right through its police powers to exercise reasonable, quote, regulation under this watered down standard, and the court quickly found that carrying concealed weapons was dangerous and therefore the legislature could ban it. In the Wurman case, it essentially followed on with that reasoning and reinforced it. In the Wurman case, the court expressly rejected the argument that the Constitutional Convention record offered any insight into whether Article 2, Section 26 spoke to whether the founders intended that very broad, unqualified language protected the right to carry a concealed weapon. I find that an interesting take on the constitutional record. Now, fast forwarding where we're at now, citizens in Arizona have the unrestricted right, aside from the right to carry a firearm to begin with. They have the right to carry concealed weapons, but under a statutory right. So as the law currently stands, the last appellate court to interpret this was the Wurman case in the Court of Appeals in 1994, which said that there is no constitutional right. But the legislature in 2010 overrode the longstanding statutory prohibition on the right for citizens to carry concealed weapons. So, interesting point, since the Arizona Supreme Court has never considered this challenge, a constitutional challenge, state constitutional challenge to a right to carry a concealed weapon. If the legislature were ultimately to change the law and reimpose a ban on the right to carry a concealed weapon, the state of the law is that the court of last resort has not spoken on this issue, and it remains an open issue of statutory, of constitutional interpretation.
Right, well, I see the panelists furiously writing questions for each other. So I feel like I am the mom up here, so I had to give Ilan some paper there. We'll go in order. So Justice Beene, do you have comments or questions for your fellow panelists?
I think I'll pass.
Okay,
I do not.
Dave?
I'll check.
Everyone is ceding their time to Ilan, so Ilan, go for it.
Sure, give it to the law professor. We have plenty we could bloviate about all day long. No, I don't know, I haven't studied this obviously, but it's interesting that textually speaking, both of the rights that were discussed to my left here, right, the freedom of speech and the Fourth Amendment equivalent, textually are narrower than the federal cognate, the federal equivalent, right? So Congress shall make no law abridging the freedom of speech. The whole question in the Alien and Sedition, or the Sedition Act controversy, was whether that was only a prohibition on prior restraints, but you can be subject, you can be liable for the abuse of that liberty by defaming government officials or others, or whether it was sort of an absolute protection after the fact. And the Federalists ended up enacting the sedition laws, but then, of course, the Jeffersonians won in 1800, and in 1960, whatever, the Supreme Court declared that the sedition acts were overruled in the court of history, right? Okay. Never actually overruled, I suppose. But the Arizona Constitution seems to adopt the Blackstonian prior restraint only view. It seems to say you can publish whatever you want, no prior restraints, subject to the abuse of that liberty. And now I'm all of a sudden terrified, worried that if someone were to take up Justice Bullock's injunction here to argue under the First Amendment, that the answer might not be what we wanted. And then Fourth Amendment, without authority of law, that seems to suggest that the legislature can pass laws authorizing officers to engage in various kinds of searches. I mean, a warrant could be considered law, authority of law, I suppose. It doesn't even say, I guess there's a common law background that requires warrants to be issued upon probable cause. It doesn't say that though, but it just says, it seems to say that the legislature, as long as there's law authorizing the search, you can go ahead and do it. Is that narrower? Is that scary, or is that good? Those are my questions.
John's champing at the bit on this one.
No, that's an interesting point, and we did not address that issue in Mixton. The dissent clearly assumed that the Private Affairs Clause required a warrant, that authority of law meant a warrant. Now, if we've started with the premise that the differences in language in the Arizona Constitution and the federal cognate must mean something, authority of law does not necessarily mean warrant, nor does it impose a probable cause requirement. Another point on that, interestingly, and this has nothing to do with the interpretation of the Constitution. We looked at the record, we looked at the language, we looked at Washington's interpretation, how its courts had approached it. Both sides did, and it's concededly a close call. It was a well-litigated case and a difficult case, and you can see by the split in the court that there I think reasonable differences in interpretations, but the dissent's interpretation would have invalidated every state statute involving compulsory process for any information that would have fit under the dissent's broad construction of what private means. And also returning to the comment about the third party doctrine, it really is, we didn't adopt the third party doctrine in whole cloth. The point of the analysis was when you're attempting to discern what a private affair, what privacy entails, the very notion requires some delineation of boundaries. And so what sort of factors do you look at? And the majority concluded that it's fair and reasonable when you're attempting to define or operationalize a term like private, whether the information has been shared with another person, but not just another person, but in this case, shared with a corporation in which you have expressly waived any right for that third party to monetize, to disseminate that information in any way that they choose. I think that cuts against a notion of privacy and a private action. And that was the point of that analysis, recognizing that reasonable, at least from my view, I think the other side had a reasonable argument. I'm not sure that Mr. Euchner would agree that our argument was reasonable.
This is called a check raise. No, both sides do have reasonable arguments, especially when you're dealing with a silent record. If all you have of the minutes of the convention are a few pages and all they said is we're bringing in the Washington Constitution, everyone says yes, and that's all you have. It's really hard to read too much more into that than what you have. With regard to the third-party doctrine, the reason why it doesn't make sense, at least to me, which is why I argued that, as when we're looking at the private affairs clause, in the context, especially at the time when there were a lot of subpoenas for business records, and the Boyd case from 1886, where Justice Bradley said this violates the Fourth and the Fifth Amendment as well, because you're making people produce records. Particularly in a post-Citizens United world where corporations are people, does a corporation no longer have any rights to its private records just because it incorporated? This is another issue that's percolating and finding its way through the court system, maybe hopefully soon. I know there was one case that made its way to the Court of Appeals and then got mooted many moons ago. Where the argument was made that just because they incorporated doesn't mean they don't have a free speech right. And therefore that doesn't mean they don't have a privacy right as well. I don't know this with 100% certainty, but I would submit that the reason why the Fourth Amendment has all of that language of probable cause and warrants upon oath and Article 2, Section 8 does not is because it was part of the common experience by 1910, whereas in the late 1700s, John Hancock suffered the indignity of general warrants on a regular basis. So the need for all that specific language was lessened by 1910. And with regard to without authority of law, there was another case that made its way from my office in 2015 and 2016 called Cisco, which involved marijuana search of, well, it was a storage locker that had been converted into a home. So there was it was a very cramped home, but it was very well decorated. So there was a state constitutional argument made as well. The Court of Appeals found that it was a search warrant case, but that because medical marijuana was legal by that point, if they're not making any kind of assertion whether this is unlawful marijuana, then this isn't going to be probable cause. The Court of Appeals agreed with that. The Supreme Court disagreed. But then moving on to the Article 2, Section 8 analysis only said, well, without authority of law doesn't mean anything different than the Fourth Amendment, and kind of shrugged it off.
So I have a question for the panelists, especially to the two justices. You know, I teach appellate advocacy, and in fact, right when COVID hit, my students were doing a state constitutional law matter dealing with the Privacy Amendment. And I was really excited. They were going to have their final panel was going to be like half the state Supreme Court. It was going to be really cool. And then COVID sort of messed it all up. But if we don't have records from our constitutional convention to look at, what would you tell advocates, many of whom are in this room, to do when they're raising, to use, what sources to use when raising state constitutional law questions? Should they be looking to the Washington Constitution? How it was interpreted in 1910, 1912. What types of arguments would be compelling at the state Supreme Court, if you can answer that?
Yeah, I think that other state constitutions with similar provisions or same provisions, such as Washington, would be something you'd want to argue. Original public meaning, obviously, at that time, what did the words mean? I think that would be especially compelling to me. I think those are probably the two things, or any type of canon of construction that might be applicable. I think those are fairly safe and useful tools to use to get arguments before us. John?
Yeah, I agree. Original public meaning is critically important if you're attempting to discern what certain words meant at that time, and there's nothing in the Constitutional Convention record. The next best thing is to try to look and see what the contemporaneous use of those words was.
For the professors and practitioners, since I know the judges can't talk about this, it seems that
best to get them to say
it seems that the privacy amendment might get some special notice now.
no comment.
I know where she's going.
I'm not tenured yet.
You're not tenured yet. All right, and Dave, I don't want to put you in a bad position.
I'll defer as well.
Okay, all right. Well, I don't want to put anyone in a bad position on that matter.
It was a post-ops type thing.
Well, yeah, I mean, that's where I was going, but sorry, Ilan, I didn't realize you didn't have tenure yet. And Dave has already been promoted on his name tag, so I don't want to put him in a bad position.
Actually, I will say one. Can I say one thing
Sure.
about that? Is I was listening to the Attorney General debate recently, and this was meant. It was a would you enforce the territorial abortion laws? And I think one of the candidates said something like, "Well, there's this thing called the Constitution. The state constitution has a privacy clause," and I was like, "Oh my gosh, there's this whole clause that I didn't realize was there." And then I realized it was the Fourth Amendment cognate. So I do think it's probably a stretch. I can say that. I'm not saying it's totally impossible or implausible, but even the substantive due process Roe v. Wade, it didn't come from the Fourth Amendment. It didn't come from the penumbral emanations of the Fourth Amendment either. Okay, that was Griswold. It came from substantive due process, right? So really, the Attorney General candidate should have said what Justice Bullock hinted at, which is we have a due process clause that was enacted during the Lochner era, and I support Lochner.
And I'll just add that at least one state Supreme Court has read their privacy clause to protect the right to an abortion.
I think there's about 11 states that have that use the actual word privacy in their privacy provisions.
You know, there's the one that made the news.
Yeah, yeah.
At the risk of embarrassing myself, what's this controversy?
Just this little thing that, yes, that's talked about a lot at law schools. I guess Ilan would know that as well. Well, I think those are all my questions, unless the panelists have questions for each other. We have a little extra time.
And we're not doing audience questions, we decided?
What?
We're not doing audience questions?
Was told no to audience questions. So, I mean, I wasn't sure if the dissent in Mixon wanted to defend himself, but, okay, go for it.
One more
Ilan.
question to the justices. And what can appellate litigators do here, actually? It's a question of sort of translating original meaning and expected application to the modern world. So a lot of what Justice Lopez said was that restrictions on concealed carry were actually understood to be very consistent with the individual right to bear arms. And why? I mean, you could regulate most rights for the public good back then, including free speech. I mean, this is pre-incorporation days. Generally when people in the 1800s concealed weapons, it's because they were up to no good, right? Well, today the problem is if you open carry a weapon, which was normal, right, it sort of creates terror in a certain segment of the population that I suppose isn't used to seeing guns in the open. And so how do you translate the original meaning? Would it translate to actually public carry can be restricted now in the public good because it creates terror in the people? And there were statutes going back to the Statute of Northampton that said if you carry arms to terrorize the people, right? I mean, it's tricky. It's a bit trickier than that. So does it translate to maybe you can prohibit open carry, but if you do, you have to permit concealed carry, even though concealed carry is what was allowed to be prohibited back then? I mean, how do you translate to a totally change in attitudes and cultures? And I don't know the answer to the question. I really am just asking.
Yeah, I'm not a gun person, so you might want to talk to Beene.
If I could add on to that question, I think that raises the question of changes in technology and how originalists, I always think of the Kylo decision and the heat sensing guns, and Justice Scalia, the woman could be in her sauna, and you could be, you're finding that out with your heat sensing guns. And so I don't know, that's really stuck with me in law school. I don't know why. It's like one of the few things I remember specifically learning. But how do we, I went to Harvard, we didn't learn much. So how do originalists deal with things like technology and cell phones, and you look at weapons, and what is a weapon has changed in size dramatically since in the last 100 years. And so how do we address that as originalists?
John?
Well, I'll go first. Oh, you want to go? No. Oh. So Kylo is Justice Scalia's anomalous opinion, where he doesn't adhere so closely to a view of what would the analog be in the 18th century, the way he did in the U.S. v. Jones majority opinion, where the GPS tracker under the bumper was the equivalent of the constable hiding in the back of the coach. To which Justice Alito responded, it would have to be the world's smallest constable and the world's largest coach. But at least the logic made sense. But with Kylo, it doesn't translate the same, because there is no, the thermal sensor to see what's going on in the home, to see what heat is emanating. There is no actual entry into the home. The dissenters analogized the thermal sensor to looking through the open window, which is not the same, because the open window, you're advertising what you're doing to the outside. Anyone with a pair of eyes could see it. But it seemed that within that one opinion, Justice Scalia seemed to acknowledge that there had to be, we couldn't just be, it wasn't as easy as what would James Madison think here. That sometimes the technology evolves so much that the founders couldn't have envisioned what it would be, and you really have to just extrapolate the principles from there and not be so concrete.
Justice Lopez?
Yeah, I agree. I mean, I think the fallback approach is to seek an analogy. I think you would consider the purpose and effect of what government action was intended to be prescribed. And I think analogies oftentimes work, but I mean, I think that's the best we could do, really.
Ilan?
I have a lot I could say, but yeah, no. Oh, okay, I will say one thing. So I can't resist. So I mean, it's obvious, right, that at least the provisions of the federal constitution as well as the state constitution, right, they're written in sufficiently broad terms to be applicable to new and changing circumstances. I'm not sure about the Kylo example, because I mean, what's a search? I mean, it's seems to fit the definition of a search, so I don't know that it's like you have to search far for it. But what I will say is, like in the Second Amendment context, which is where people argue this, like, well, okay, you have a right to carry muskets or something. I mean, that's ridiculous. That's not what originalism is, right? Originalism is not how did the founders expect their text to apply in the real world? The question is, what is the meaning of the text they wrote, and how does that apply in the modern world, in the current world, to current facts, and how they thought it would apply in their time to their circumstances is obviously evidence of what the meaning is, but we're not limited to their original expected application, right? We're limited to what they wrote. Now, in the context of the Second Amendment, I actually think it's just very interesting, and because I've heard people argue this lately, and I have an excuse to talk about it now, I'll say it. Is the Second Amendment, right, limited to this idea of sort of military service? Why do we have a militia? What kind of weapons does that mean? Is it only self-defense in the home? And what does technology tell us about this? Now here, I might get in trouble, so don't share this with the ASU administration. But what I will say, like a lot of people say that, oh, we need the militia. Individuals have to have an individual right to bear arms as part of a militia to prevent against government tyranny. Okay? And on the other side, they say, no, it's only, I mean, I don't know, I guess, what the other side responds to that. But it's actually, there's a better argument. There's sort of a better argument here. and I promise it's connected to the question, which is Article 1, Section 8, Clause 15 of the Constitution does tell us why we have a militia. And it's not to protect against government tyranny. Okay? It says Congress may provide for calling forth a militia to do 3 things: execute the laws of the Union, suppress insurrection, and repel invasion. This isn't about government tyranny. Okay? This is about the Red Dawn situation. Okay, the 1980s Red Dawn movie, not the North Korea Red Dawn movie, which was terrible. Okay? It's sometimes the people need to be armed and ready in case there's an insurrection, which apparently we've had some recently. Okay? To repel invasions, which apparently we have one right now in Arizona. Okay? I mean, so the point is, it's not just for government tyranny. It's actually so the citizens are prepared to defend the state. Okay? What does that mean? I don't think it means you necessarily get to have a bazooka or a tank. But I do suspect it means that you can have a weapon that your average Marine goes into Iraq with. I do suspect that that's probably a better originalist interpretation. And again, I'll deny that I've ever said this. And I'll say that the video is a deep fake, if anyone.
Well, Ilan, you can carry your musket, and I'll have my handwritten pamphlets that I hand around, and we'll all be equal. All right, well, please join me in thanking our panelists.
That was really fun.